Good morning, everyone. Good morning, everyone. Let's get started. Today, we are here to talk about wetlands conservation after Sackett versus EPA. I'm Kevin Washburn, and I want to welcome you to the College of Law. I first need to thank Charlotte and Fred Hubbell for creating the Hubbell Environmental Law Initiative and giving us another great event. Thank you. I also want to thank the dynamic duo of Professor Shannon Raisler and Staff Director Blake Rupie for making this happen today. All right, so let's get started. Prior to Sackett versus EPA, we had several Supreme Court decisions and dueling regulatory definitions concerning the proper standard for how to determine whether a wetland or a stream that is not navigable, in fact, is properly considered among the waters of the United States. And if I say WOTUS, that means waters of the United States. With respect to adjacent wetlands, the opinion worked through the history of the Clean Water Act, the Sackett opinion, and analyzes the statutory text to conclude that the act reflects Congress's assumption that certain adjacent wetlands are part of the waters of the United States. To assert jurisdiction over adjacent wetlands, you need a relatively permanent body of water connected to traditional interstate navigable waters. And second, you need a wetland that has a continuous surface connection with the water, making it difficult to determine where the water ends and the wetland begins. That's sort of what the Supreme Court told us. The new WOTUS rule, prepared by the Corps of Engineers and EPA, significantly narrows the geographic reach of the Clean Water Act, excluding, for example, wetlands that lack a continuous surface connection to traditionally navigable waters, intermittent and ephemeral streams located, for example, in the arid west might not be considered jurisdictional under the new rule, given that they are not relatively permanent, standing, or continuously flowing bodies of water. So that's the kind of the outcome to some degree of the Sackett versus EPA on the law. My job, other than to kind of kick us off, is to introduce and help moderate a discussion with Assistant Secretary of the Army for Civil Works, Michael Connor, and Sarah Krakoff, who is the Deputy Solicitor for Fish, Wildlife, and Parks at the U.S. Department of the Interior. We are so lucky we got both of them here for a number of reasons. We invited them both thinking, well, maybe one of them will be able to make it. And we're so lucky we got both of them. Secretary Connor, let me introduce him first. He began his role in 2021. He's both an engineer and a lawyer, and he's also an enrolled member of the Taos Pueblo of northern New Mexico. I've known him since we were both baby lawyers, and I can tell you he worked for several years. He worked as an engineer before he went to law school, but then he worked at the solicitor's office for a long time, did Indian water rights for a while at Interior, and then ended up working at the U.S. Senate, the Energy and Natural Resources Committee of the U.S. Senate for 8 or 9 years, something like that. And then went into government, back into the executive branch, I guess, in the Obama administration, where he served as the commissioner of the Bureau of Reclamation, which runs, what is it, 380 dams out west, 400 something? 480, okay, 480 dams, yeah. So this is, so he did that for a while, and then he was Deputy Secretary of the Department of the Interior for a while as well. And then he went to he went to private practice for a little while at the end of the Obama administration, and then he went. Whoops, I'm sorry, I just changed something. Like there we go, and went back into the administration in 2021 as the Assistant Secretary for Civil Works of the Army, which means that he runs the Corps of Engineers. He's the political lead in charge of the Army Corps of Engineers, which also runs dams. So this is not his first dam rodeo. We're lucky to have him here today, and I'm going to look forward to hearing from him. Sarah Krakoff has an equally fascinating career. She began her career at a little legal services agency on the Navajo reservation called DNA People's Legal Services, and spent a lot of time at the Navajo reservation, very rural reservation located in the desert in the Four Corners region of the United States, and was there for quite a while, and then became a professor at the University of Colorado. And she's spent a lot of time as a professor, and she's on leave from being a chaired professor at the University of Colorado to serve in the administration. But at Colorado, she has written numerous articles about resource issues in public lands and federal Indian law. I'm currently teaching the course in federal Indian law, and the case book that I'm using has her name on the spine. She's the author, but she's written a bunch of other things besides. And so she's really well known. She's a Westerner, so and she takes that as her mandate, I guess. She writes a lot about the West generally, including a really important article fairly recently about the Grand Canyon. Her clients, she's now, again, the Deputy Solicitor for Fish, Wildlife, and Parks at the U.S. Department of the Interior. And her clients are the Fish and Wildlife Service, which has a lot of concern and issues involving wetlands, and the National Park Service, which is the fair-haired child of the Department of the Interior, we like to say. Everybody likes the parks. Everything else is controversial, but everybody likes the parks. So being the lawyer for the parks is probably a lot easier than being the lawyer for Fish and Wildlife Service. But both are very important jobs, and we're so glad to have her here today. She got in at 1:30 or something like that last night, so after some flight delays, so we're really grateful. I'm going to turn it over to Mike Connor to say a few words first. Let me say one of the reasons we're lucky to have him here is that he was vacationing with his family a couple of weeks ago in Europe when a barge hit a bridge in near Baltimore and caused some tragic loss of life, but also did, billions of dollars damage, I guess we will ultimately determine. And he got back from Europe and found that was his job to sort that out. So maybe he'll tell us a little bit about that as well today. Great. Mike?
Excellent. Good morning, everybody. It's great to be here in Iowa. As I understand it, this is the second most important event happening today from the University of Iowa's perspective. And I'm glad that tailgating or the Final Four equivalent does not happen at 10:30 in the morning, because you're all probably anxious to start, which will surely be, I'm anxious to get back to Denver tonight and take in the game also. So it's Kevin Dean Washburn's magnetic personality that draws us here to the University of Iowa. And as he's mentioned, I noticed he stayed away from how long we've known each other, just a long time. So I'll do the same. But baby lawyers is the equivalent term. I think we met the first month that both of us started in federal service, me at the Department of the Interior and Kevin at the Department of Justice. And it's been a wonderful relationship ever since then, which I highly value, as long as my longstanding relationship with Sarah Krakoff from the University of Colorado, and now, of course, leading efforts at the Interior Department. I'm just lucky to be, I've known Sarah also a long time. Also, we've had the same mentors and people who we admire and trust at the University of Colorado, and I wouldn't be anywhere close to this position if I hadn't had that as my foundation in law school. So take note of the great value you have, those of you students. These people mean a great deal in your life as you move on. And so with that, let me kick off by saying I'm happy to talk about Sackett. Actually, I'm never happy to talk about Sackett, to be totally blunt, but I'll get into that because I just want to remind folks, and I think Kevin gave me the segue of what the Army Corps of Engineers does in its totality for this nation. And I was formerly Deputy Secretary at the Interior Department with 10 separate agencies, all with different missions. I come in and I get to the honor of overseeing the Army Corps of Engineers, which has 9 monster missions associated with its responsibilities. It starts with what we call the primary missions, which is aquatic ecosystem restoration, navigation, the first mission of the Army Corps of Engineers, flood risk management, whether it's coastal or of our riverine systems. Those are the three primary mission areas for the Army Corps of Engineers. Beyond that, we are probably the second largest recreational provider in the federal government. Overall, we are the nation's regulator when it comes to the Clean Water Act, as well as the River and Harbors Act, and doing all the permit associated with Section 404, although we'll talk about that, the U.S. Supreme Court is trying to manage our workload in a reduced capacity these days. Beyond that, we're also the nation's single largest producer of hydropower. We provide water supply. We run a program called FOOSRAP, which I never get the acronym right, but we remediate the sites of formerly utilized nuclear production facilities. And then lastly, and most relevant, I'd say over the last 6 months, as well as this past week in particular, is our emergency and disaster response function. We are the nation's engineer and immediate response entity, contract with FEMA as in carrying out missions post-disaster, everything from emergency power to debris removal to blue roofs post-hurricanes to constructing critical infrastructure necessary for communities. And I'll talk a little bit about that more, but it's a monster mission. And if you put it in its totality of what our annual budget is, it's about $8 to $9 billion per year. And you add in all the disaster supplementals that have occurred or infrastructure initiatives, such as the president's bipartisan infrastructure law. We are on average over the last decade about a $14 to $15 billion per year agency, which coincidentally is on par with the U.S. Department of the Interior as far as the average resources for an organization. So it is a long and storied organization. I am the luckiest person in the world to be able to oversee it. It started with George Washington in 1775. Setting forth the first engineer officers that he needed to carry out the mission at that point in time. 1802 was the establishment, formerly the U.S. Army Corps of Engineers, and that is exactly 100 years before the U.S. Bureau of Reclamation was established in 1902, coincidentally enough. So I would just point out, in particular, given today, I am happy to be here, and I'm happy that I have a great partner who is the Chief of Engineers, 3-star General, Lieutenant General Scott Spellman, who is accompanying the president almost as we speak. He's probably waiting at Marine One right now for the president so they can go up to Baltimore Harbor, and the president is surveying the damage and the mission that we're undertaking now to clear that channel, which is the 9th largest port in cargo volume in the country and the single largest port for the movement of vehicles, imports and export vehicles from this country. So this is a huge economic driver. And along those lines, I would also just note, very happy to have Colonel Jess Curry here, who is the commander of the Rock Island District in Illinois, whose responsibilities for the state of Iowa, particularly from a regulatory standpoint, but a lot of flood control projects. Colonel Curry, getting back to that emergency disaster mission, just led for 6 months our emergency response in Maui post-wildfire. So same situation. Had to go in there, provide emergency power, had to go out in there and do the debris removal necessary to allow families to move back into their homes, have those site cleared of toxic hazardous waste, then just pure debris. Colonel Curry led the effort to build a new elementary school in 95 days to turn over to the local school district, which he successfully did on around March 1st, the completion of the school. And I think he just turned it over a couple of days ago to the school district. The Maui wildfire event happened the day before school started in 2023. And so these kids are now back to a permanent facility because of the great work of Colonel Curry and the whole Army Corps of Engineer teams with the whole of a government approach. But it's just, I say that because I'd like to talk about anything other than Sackett, first of all. And then it's just, it just resonates given where we've been in particular recently. And as much as those 9 missions take precedent, over our day-to-day work, these events that are on the front page of the news and that fade away sometimes, but they're long periods of recovery and restoration. And Army Corps of Engineers is at the heart of that. So I just wanted to make that point. So last part of the overview, I'll just say my job as Assistant Secretary and overseeing the Army Corps of Engineers is to use this wonderful organization, its resources, experiences, capabilities to basically prioritize and move forward the president's agenda. How do we appropriately do that using this organization? That was my job at Interior when I was Deputy Secretary in partnership with the Secretary, of course, who led that effort. But it's my job here overseeing the Army Corps of Engineers. So we've set out some priorities to highlight that is to, first of all, focus on upgrading the nation's ports and waterways to ensure we're building and strengthening our supply chains and laying the foundation for economic growth. We are modernizing the Civil Works program to better serve marginalized communities. This is a high priority of the president. We are building climate resilient, innovative approaches to infrastructure to protect communities and ecosystems. We're investing in science and research and development to ensure we have enduring water resource solutions. And most fundamental is always to strengthen our communications and our partnerships, because nothing we do we do alone in this endeavor, whether it's civil works projects, we cost share them, whether it's disaster response, it's a whole of government effort. Those are our priorities, and those, I think, speak highly to President Biden's overall agenda and priorities for the country. And so from that standpoint, let's get into the subject at hand, because I probably can't get away with not doing that. All right. So, waters of the United States, WOTUS. The groundwork is that we have a Sackett decision in 2023, the fourth very significant U.S. Supreme Court decision trying to move us towards a definition that everybody can agree on with respect to waters of the United States. And I don't think the Supreme Court has been successful in that endeavor in any way, shape, or form, because nobody's going to agree that this last decision in Sackett was any more defining of waters of the U.S. than any of the other three. So you've got Riverside Bayview in 1985, which established the foundation about the appropriateness of the need for permits for any fill activity associated with waters of the United States. You had the Swank decision in 2001, basically where we, Army Corps, attempted to tie the jurisdiction associated with the Clean Water Act to the migratory bird rule, and then we're told that, isolated wetlands did not fit the category of waters of the United States. You have the Rapanos case from 2006, where the plurality made clear it was relatively permanent waters with also wetlands that are connected with continuous surface connection activities. And you had Justice Kennedy adding the significant nexus test in his concurrence, which was the foundation for the rule post Rapanos. And then you've got the Supreme Court acting again in 2023 to basically say, nope, not significant nexus. That doesn't apply. That's not a valid interpretation of the Clean Water Act. And so now we've got excising that part is clear, significant nexus, which has been part of the regulatory framework pre-2015 and most recently with the Clean Water Rule in 2015, and then our rule that we issued in January of 2023. That aspect of the rule is no longer valid post Sackett in the question, which I'll let all of you debate. I have my own views. I'm not going to get into that today, as did Sackett just go back to the Rapanos plurality, or did it add some other extra layer of interpretation beyond significant nexus? So, but our job, I can in non-public, quiet situations, tell you my private thoughts about all of that. But it doesn't matter what my private thoughts are, quite frankly, on any of that. This administration follows the rule of law. The Supreme Court has spoken pretty clearly in this area. And so from that standpoint, our job post Sackett was immediately to pivot and change and excise those portions of our January 2023 rule, which were no longer valid, that being really the significant nexus portion of the test, as well as, the wetlands test that we attributed to interstate wetlands. There were other aspects of the January 2023 rule that we surgically removed because we had an idea that some of these parts of the rule were at risk with Sackett pending. So we moved with just phenomenal speed, quite frankly, from a late May decision 2023 to then September 8th publishing a conforming rule for the definition of waters of the United States. So that was once again a whole of administration approach to get EPA, Army Corps on the same page, to work through the very bureaucratic processes, the Office of Management Budget, and the interagency process to get a rule published. And we're very proud of that aspect of how quickly we moved to implement the Supreme Court's decision. So post conforming rule, we next turn to coordination memos, working through what is meant by the Supreme Court's decision in Sackett, and particularly continuous surface connection, that part of their ruling. We know there are going to be factual questions, issues, so we immediately pivoted at the end of September to issue coordination memos between the Army Corps of Engineers and EPA, how we would elevate those jurisdictional determinations that we make on a daily, weekly basis through all of our districts and the regulatory programs that we have. We'd have a process there to those factionally questionable situations that we could work up through EPA headquarters, Army Corps of Engineers, and ultimately between the Army itself and EPA. So that was the second step in moving forward. And then getting back to jurisdictional determinations, which had been pending since the Sackett decision. And we had well over 4,000 jurisdictional determinations that were pending at the time. And we've moved forward very expeditiously post-rule to try and work through, I think, around 700 of those AJDs are now fully completed. I think around 130, 140 have been elevated through that process I talked about, and we've moved forward and made determinations, I think, on almost 100 of those. So we've got about 40 to 50 jurisdictional determinations now that are pending that are really focused on continuous surface connection. And we are having, weekly meetings between the Army, EPA, Department of Justice as we move forward to start making decisions on those particular jurisdictional determinations. That's how we're going to provide, essentially fact-specific guidance to the teams that they can move out and use those determinations. And then hopefully we will soon get to guidance itself as part of that process. So the estimate that EPA and Army Corps staff, primarily EPA folks, came up with when the Navigable Waters Protection Rule, this is the Waters of the U.S. rule that was put in place during the Trump administration. The projection that was used then, the analysis, and then subsequently some additional analysis that was done when we rescinded that rule, did a new rule in January of 2023, was about 70% loss of jurisdiction because it's not equivalent. Our conforming rule is not the same as the Navigable Waters Protection Rule, but post-Sackett, they're, almost in line. So 70% is the general figure about loss of jurisdiction. So in the aftermath of that, it's just clear to the extent that we've relied on regulatory program as a primary way to protect wetlands through a permitting process that requires mitigation. We've got to think a little bit more differently post-Sackett under any scenario. There'll be litigation, there'll be continued discussion about what Sackett means. So we've been thinking about that too, after issuing conforming rule, after getting back to jurisdictional determinations, after having a process to elevate our discussions and how we make those determinations. And now it's what other programs, activities do we have in hand to try and move forward and protect, restore, enhance wetlands. Wetlands, as we all know, are critical from the standpoint of they attenuate floods. They provide and improve water quality. They provide great habitat for a lot of species, threatened and endangered species, and they are great storage of water and an increasingly critical arid environment that we're facing, particularly in the Western U.S. Wetlands are absolutely critical, and it doesn't matter if they're jurisdictional or non-jurisdictional. They're critical to our water resources and the health of our watershed. So we have thought through how do we do that? Well, as I mentioned earlier, primary mission is aquatic ecosystem restoration. We have a lot of programs, large scale. There's nothing more large scale than Everglades restoration, to which we invest about now under President Biden's leadership, $450 million a year in Everglades restoration. But we also have small programs, continuing authority programs that we can do without additional congressional authorization for up to about $15 million. You can do a lot of good work, in particular smaller watersheds with $15 million. So we want to make more use of our Aquatic Ecosystem 206 program. We just included a significant bump up for that program in our 2025 budget. That's fundamental to how we're going to pivot post-Sackett to do the job that we need to do in protecting, restoring, and enhancing wetlands. Our technical assistance programs, we have a lot of programs. There are states that are very active in assessing how their role might change in a post-Sackett landscape. We've got a lot of permitting expertise. We've got a lot of technical expertise. We want to offer that. We've got significant resources through our planning assistance to state programs, and that's whether they're states, whether they're tribal nations, whether they're local communities. We want to offer those programs. We're going to be transparent so that the public understands the implications of Sackett. We're going to continue to make sure we publish all of our jurisdictional terminations, and we're going to refocus on our compensatory mitigation programs. We have not always consistently applied the 2008 mitigation rule across the Army Corps of Engineers. It's not just using jurisdictional wetlands restoration as appropriate mitigation. As I mentioned before, all wetlands have an important role to play, and so we can credit those non-jurisdictional as well as jurisdictional wetlands, and we want to move forward and make sure we've got better, more expansive application of our mitigation rule. Yesterday, I spent the day with the city of Coralville. No, was it? I forgot which. Okay, I'm getting a thumbs up from Colonel Curry, keeping me right. On a very innovative stream mitigation program that they've got to build credits as part of a mitigation bank program. Great innovative work that seems to be exploding here in Iowa. And I think at the foundation is the great work that the Rock Island District is doing in promoting those type of programs. And then finally, nature-based solutions. It's just critical that the Corps moves forward and is even more aggressive on nature-based solutions and how we, do our role as part of our civil works projects, how we integrate the, floodplain reconnectivity, the construction of tidal wetlands, all the work that we can do to use our programs and tools to advance nature-based solutions, use wetlands, use water resources to control water resources. The Corps has done a great job of expanding that gradually. In addition to the March 22nd memo I issued on World Water Day, look forward to another directive about nature-based solutions in the very near future as we try and ensure that the Corps is more methodically planning for nature-based solutions that were in our dredging program as part of our navigation program, that we're beneficially using that material to build new wetlands and other great habitats. The Chief has issued an initiative and a directive to the Corps to move from 35% use of dredge material to 70% by 2030. That's greatly spurs the innovative and creative thinking when the chief, the boss for the Army Corps of Engineers gives that kind of directive. And there's great examples I can talk about later when we get into Q&A, but I have used my allotment of time and need to turn it over to Kevin and Ms. Krakoff to carry on the discussion. Thanks.
Sarah needs just a moment to get her PowerPoint set, but actually maybe it won't take that long at all. Blake's on it. Thank you, Blake.
Thanks, Blake. And thank you to Dean Washburn, Professor Raessler, and the law school here for hosting us. I used to do this a lot in my previous job. That is, fly around and give lectures and public speeches and so forth. But for the last 3 years, as Kevin noted, I've been Deputy Solicitor for Parks and Wildlife at the Department of the Interior. And so that's sort of a backroom job. We sit there and we type and shoot memos over to our political counterparts and aren't like in front of the microphone too much. So I hope you'll be patient with me as I re-enter this world of public speaking. The three of us have known each other a long time. I'm not always at the same time. I met Mike later than I met Kevin. Kevin failed to mention that we also met when we were baby lawyers. The reason he knows so much about where I lived on the Navajo Nation was because he was working for the U.S. Attorney's Office at the time. He was an AUSA and had some work out there. So our worlds intersected there on the high desert of northern Arizona. And we've been friends and colleagues ever since in a variety of ways. And then, of course, the other connection we all share is both Kevin and Mike are prominent alumni of the Department of the Interior. Kevin was Assistant Secretary for Indian Affairs, and Mike, in his last position there, was Deputy Secretary, but he also ran the Bureau of Reclamation. And this is my first tour of federal service. Unlike these two, I didn't do an earlier stint there. I was a legal services lawyer and then a professor. And I just want to give a plug to working for the federal government. It doesn't matter what your partisan affiliation is. It is remarkable, all the good work that goes on inside the hallways of the Department of the Interior, inside Army Corps of Engineers, all the federal agencies, that's unseen, that isn't the controversial regulatory work, and frankly, isn't done by us politicals. We like to think we do a good job, but we're temps. There's like an army, hundreds and thousands of career employees just doing work that supports all of us. And for me, it's been a tremendous and really very heartening learning experience. And those folks are there no matter what administration comes and goes. And they do a lot of the work to protect, for example, our wetlands, even with a changing regulatory environment, with a whole bunch of different and interesting tools. So I just wanted to share that with you all, especially the law students. If you're graduating and thinking about government service, think hard about it. It's a really great learning experience, great option. And there are folks who spent their entire careers, for example, in the solicitor's office of the Department of the Interior. And there's a reason for that, right? It's great work, it's rewarding, it pays pretty well, yet it's a humane lifestyle. So think about all those things as you go through law school and then move on to your next job. And finally, I will say this administration working for the department under Secretary Holland has been a tremendous honor. There's a real spirit of teamwork. It's a very highly ethical department. She is our true north and leader in all things that we do at the Department of the Interior to serve the American people. And so I just wanted to mention, couldn't be more proud and honored to work for her. So with that, I'll give you the bottom line up front that as Mike mentioned, the effects of Sackett are real, right? That's no small number, that it's a roughly 70% loss on the regulatory side of federal jurisdictional wetlands. But the Department of the Interior still has lots of valuable tools to protect wetlands, right? Regulation is just one tool. And there are sort of two other big buckets of tools that I'll talk about later. And I'll just remind maybe share with folks for whom the Department of the Interior isn't a big part of your daily lives, that we manage 1/3 of the nation's land. And so we don't rely on regulatory tools for a lot of what we do because we are in fact the land managers, and that implies a different kind of regulation, right? But we own and manage the wetlands for the American people. And so that gives us options that the more purely regulatory agencies like the Environmental Protection Agency don't have. So I just wanted to start there because, and it is where Mike ended, and it's very true and real that a narrower regulatory world doesn't mean less protection of wetlands. So here's my history of federal wetlands protection on one slide. And before marching through the bullets there, I thought I'd just start by, I know we kind of just dove in, and Mike talked a little bit about the importance of wetlands at the end of his remarks. I just thought I'd start there because it informs this one slide history of going from, pre-settlement to now. The history of federal wetlands protection sort of tracks our knowledge of the importance of wetlands. Now we understand that there are water filters, there are flood protection. Wetlands provide habitat for about 50% of listed threatened or endangered species under the Endangered Species Act. So today we say, they provide a huge range of ecosystem services at a very low cost. We don't have to pay the wetlands themselves to do all this work. But, that sort of, I'd say, is only knowledge we have in the last 50 years or so. And so that knowledge, is now we're from the 1970s on trying to protect on top of a literal landscape that for the first, couple hundred years of the nation, there were other values at stake, and we recruited, the power of the federal government, frankly, to an opposite end. So pre-19th century, there were roughly 250 million acres of wetlands in the contiguous United States. And then by the 1950s, we had 120 million acres, right? So more than 50% loss of wetlands throughout the nation. And laws played a huge part in that. There were federal policies all consistent with the era of federal lands disposition and the desire to settle the West and encourage farming that subsidize the drainage and loss of wetlands so that there could be agriculture, right? These are good and understandable reasons, but we didn't know at the time that there might have been other methods to encourage wide-scale farming without the significant wetlands loss. But, hindsight is always 20/20. So just one big example is, because it was literally called the Swamplands Act of 1849 and 1850, is a disposition era law that encouraged draining and conservation. It basically gave land from the federal government to the states on the condition that those lands be drained for farming. And that's a big part of the story of Iowa, the state that we're in, which is about 90% to 95% loss of wetlands since that sort of pre-colonial period. And there's a lot of wonderful farming that we all rely on as a result. So that's the backdrop, so that by the time we realized the important role of wetlands in about the 1970s or so, or earlier, but regulatory efforts were fits and starts until then, we were operating against that backdrop of relative loss, or absolute loss, not relative loss. So the big regulatory pieces that came in the 1970s, of course, include the Clean Water Act and then other federal environmental laws like the National Environmental Policy Act, which adds a layer of analysis to everything that the federal government does. But the Clean Water Act is the centerpiece for us. And it was passed in 1972, and the 77 amendments added this language of wetlands adjacent to waters of the United States, which is what the Supreme Court has been interpreting ever since. Other big landmarks in terms of the shift to wetlands protection, in terms of the federal commitment, were President Carter's Executive Order 11990, those never sound too sexy or exciting, but it was the first, message from the president out to all the departments, the Department of the Interior, the Army Corps, every single federal agency, please go forth and use your own authorities to protect wetlands. So not a regulatory mechanism, but a let's shift priorities kind of executive order. And those are those like hidden legal things that can make a huge difference actually in what the federal government accomplishes, that also have the upside of being less controversial, less visible, but less controversial. And ever since President Carter's executive order, there's been a consistent theme. Every single administration has supported wetlands protection, with varying degrees of throwing their heft behind it. But nobody has backed off of that large goal. And of course, very famously, at least to people my age, maybe not to the law students here, George H.W. Bush, when he was president, he was a very big conservationist, significant environmentalist before he came into office, and he continued to be consistent with those commitments as president. He announced the no net loss of wetlands policy during his presidency. And then during the Reagan years, there wasn't a whole lot of executive action, but there was legislation passed, the swamp buster provisions of the Food Security Act. That's agriculture, not interior, but I'm going to throw my sister agency a bone. They also play a big role in incentivizing the protection of wetlands through programs that reward farmers for not draining, right? For not farming on recently drained swamplands. So that was a little out of order. I do know that Reagan preceded H.W. Bush. You can see that on my slide. So despite all of this consistent, and strongly led effort from the federal government that was supported by states and also tribal nations from about the 1970s on, there has actually been a consistent thread of continuous loss of wetlands. And the Fish and Wildlife Service, among the many things that they do in this arena, publishes a report, comes out about every 10 years or so. And their report, which caps data from 2010 to 2019, just came out in 2024. I realize that is sometimes the case, the federal government, unlike the Army Corps, which can build a school in 90 days. Anyway, this report just came out, but its last date of loss, because it takes a while for scientists to analyze data, is 2019. And unfortunately, it shows that we have had a net loss. So we've lost roughly 221,000 acres of wetlands since the last report. So, since the sort of 2010 period. So what do we make of all of that? I mean, in some ways, that's pre-Sackett rule, right? So that could be a really depressing idea. Like ever since the 1970s, no net losses, and actually, yes, still net losses, but I'm a crazy optimist, so I think you should see it this way, and I'll talk you through it. We've always needed tools that were broader than the regulatory tool, and we all know that. And there is, unfortunately, when the federal government is exercising what it rightly believes under the law is the full scope of regulatory authority, there can be a lot of resistance. And so over the years, we have to adapt and find different tools that spark less conflict and resistance. And that has always been true. So if we haven't been winning the no net losses war on behalf of our wetlands in a pre-Sackett era, maybe there's less reason to be concerned, right? That we're going to lose even more. I realize that's trying to take lemons and make lemonade, but that's what we're here to do. And I actually believe it. And we'll get to a little bit more about why in a second. I'm going to actually maybe mostly skip this slide because Mike talked you through the evolution of the doctrine in the Supreme Court interpreting our Waters of the United States rule, and just get to the punchline, which is, Sackett does represent a significant shift. Even if all it does is go back to Rapanos in terms of the broader definition of waters of the United States, it provided, clarity, right? A 5-justice majority opinion on a narrower definition of wetlands, adjacent wetlands. So pre-Sackett, we had the significant nexus to navigable waters test, and that allowed for hydrologists working for the Corps and EPA to look at, the hydrological definition of wetlands and not use adjacent and, what some people I think would describe as this wooden way like right next door, but rather, hydrologically connected. And that's what they thought Congress meant in using that term, because the court, because Congress adopted the words that actually the Army Corps had been using that had that definition. But, the Supreme Court in Sackett said, nope, we're not going to use a significant nexus test for adjacent wetlands. Instead, wetlands must have, as Mike said, a continuous service connection. One small footnote to that is that the court said itself, that doesn't mean like 24/7, 365 days a year, right? A continuous connection can still be dry sometimes if there's a period of drought. But nonetheless, there has to be this, in general, continuous surface connection with covered waters, and the wetlands must, quote unquote, as a practical matter, be indistinguishable from waters of the United States. So that's our new understanding. And so what are the effects on the Department of the Interior, right? If the Army Corps can cover roughly 70% fewer waters as waters of the United States defined as wetlands, and same with the EPA, right? They're the permitters, they're the regulators. How does that affect what we do on the Department of the Interior side? Well, there are clear regulatory effects, and these are our two biggest examples. Under a statute called the Fish and Wildlife Coordination Act, the Fish and Wildlife Service consults with the Army Corps anytime there is an action that affects fish and wildlife, right? When waters of the United States are affected. So there will be less consultation by the Fish and Wildlife Service in contexts in which actions affect waters of the United States under this narrow definition of wetlands. So that's a kind of lesser known consultation role the Fish and Wildlife Service plays. And then the bigger one, much better known one, is under the Endangered Species Act, which the Fish and Wildlife Service administers along with NOAA, National Oceanic and Atmospheric Administration in the Department of Commerce. Section 782 of the Endangered Species Act requires federal agencies to ensure that their actions are not likely to jeopardize listed species or destroy or adversely modify critical habitat. So that's a burden on all the other agencies, not the Fish and Wildlife Service, but the important role the service plays is that they consult with these other federal agencies, we call them action agencies, anytime they're doing something that might lead to the jeopardy or adverse modification of critical habitat. And the Army Corps is one of the Fish and Wildlife Service's biggest customers because they consult when issuing permits under the Clean Water Act. So with fewer permits being issued after Sackett, right? So the Army Corps is a little bit out of the business of issuing permits for what they call dredge and fill of wetlands. Then we're also a little bit out of that consultation business, which means that when people are now, taking actions on wetlands, Army Corps is not the regulator, Army Corps and EPA. And so there's no federal action for the Fish and Wildlife Service to consult about to figure out whether that agency is or is not jeopardizing an endangered species. So that's, and roughly half of endangered species rely on wetlands as critical habitat. So that's a big effect, but don't despair if what you care about are the protection of threatened endangered species, because the Endangered Species Act protects species no matter where they are. It doesn't matter if the actor is a federal actor or not. There are still what are called the no-take provisions in the Endangered Species Act, so you can't kill, hunt, trap, harm, shoot, etc. It's a long list. Endangered or threatened species on private lands either. So it will just shift for this part of the Endangered Species Act. It will just shift the regulatory focus from our Section 7 consultation tool to probably, if private people are now worried, like, oh, I don't have the protection of a federal consultation and therefore a permit to do what I'm going to do under the ESA, I might seek out what's called a Section 10 permit as a private person and get what's called an incidental take, permission to take by accident, not on purpose, a threatened or endangered species. So the ESA can continue to be enforced just in a different way. But I will say that without that initial federal action, it will just mean probably a lot of actions that affect species are less understood or known about by the Fish and Wildlife Service. So I don't want to paint too rosy a picture about this regulatory loss. It will mean, there just is a less understanding developed early on of actions when you dredge and fill wetlands that could affect threatened or endangered species. Because our federal agents who consult with us, they're used to it. They're good partners. We work pretty well to figure out, you can tweak the program this way or that, and have the landowner do this or that, all in the front end. So there will be a kind of front end regulatory loss in terms of effectiveness, probably, at least initially, the Endangered Species Act. So those are some of the effects that are clear, and we'll see, how that affects the Fish and Wildlife Service's work and effects on aquatic and terrestrial species that depend on wetlands. But, regulation is just one tool. There are others, especially, again, when you're the nation's federal land manager, and we might group them right. There's sort of, in terms of conservation tools, there's regulation, there's public ownership or protection, right? The public just taking on the role of the manager and owner of the relevant resources. And then there are economic incentives, and or norms that create self-enforcing mechanisms for protection. And here, the Fish and Wildlife Service and the Department of the Interior in general, we have a lot of options. So among the third of the nation's lands that we manage are the Fish and Wildlife Refuge System. And the Fish and Wildlife Refuge System, unlike the National Park Service that Kevin mentioned, the National Park Service is like the favored child. And some people might say the spoiled child, get all the attention, all the goodies, America's greatest idea and all that stuff. And then there are the quieter children working really hard to protect our ecosystem services and also, aesthetic. They have huge aesthetic value. And the refuge system has a lot of wetlands in it. Right here in Iowa, the Fish and Wildlife Service plays a role in managing and protecting wetlands along with the Iowa Department of Natural Resources. I hope I'm calling that the right thing, along with the state agency. They, have so you could say the slightly more homely protected lands that do a lot of work for us. There's a lot of waterfowl. A lot of people go hunting and fishing within our National Wildlife Refuge System. The Fish and Wildlife Service also has what's called a prairie pothole easement program. So when the Corps had to stop regulating after the Swank decision, those prairie potholes, the Fish and Wildlife Service, which had this program that pre-existed the regulatory tool, you could say it became all the more important. We pay farmers for the prairie pothole easement on their property, and then they can't develop that. And that's a way to use that third, economic incentive self-enforcing mechanism tool to protect wetlands. And then there are the Bureau of Reclamation, likewise, as I mentioned earlier, has shifted from its role of predominantly, it still is a predominant role of providing water to farmers in the West and reclaiming lands by draining them, damming and irrigating, to, investing in programs like our Water Smart program that restores, where the agricultural landowners and others can use funding to restore wetlands that help them make better use, more efficient use of their water for agriculture and farming. So those two huge, if there are three legs to the stool to conservation regulations, those two are utterly unaffected by Sackett. And chances are they will increase in importance and prominence in the ways that Mike also described in the coming years. So what can and should we do next? And then I'll just turn it back over to Kevin, and we can talk about this because Mike and Kevin and I talked about this as a possible example of an area clearly affected by the Sackett rule, but very important to the nation and even to the world because of its values as a huge intact scenic wetlands. And so I'm just going to leave you with the photos of it, and then we can talk through it or not. We can see what Kevin wants to talk about. So is the Okefenokee, sometimes called the Okefenokee Swamp in Georgia, sort of a case study in real time of can we, take my optimistic take on all of this and make it real, or, will we see real effects and losses in the post-Sackett world? It's a huge intact wetland. There's a Fish and Wildlife Service refuge there, the Okefenokee National Wildlife Refuge. So we have that tool already, but there's a mine proposed on the edge of the refuge, which in pre-Sackett, Mike might have been able to affect through permitting, but now it's pretty clear, like, nope. So we can talk through what we can do. So here's just a few images of the Okefenokee. I've never been there, but now I kind of want to go. That fellow lives there. Yeah, could visit him. Okay, and you can put those pictures back up or not, Kevin, if you want. But anyway, that's a quick tour through effects of Sackett, but also all the options left open to us. And I hope a sense of the ways in which regulation is just one tool in the toolkit, and that's always been so, right? That's always been so, and there's always been relative upsides and relative ineffectiveness.
Okay, I'm going to open it up for questions from all of you soon. So please feel free to let us know. There's a button on the mic in front of you, and we ask you to press that button if you ask a question. But I've got one or two just to get us started. And really, I liked where you ended, Sarah, because it was nice to know, like, where's the rubber meet the road? Where are the challenges going to present? And Okefenokee sounds like one. And so one of the questions I had, the report that you talked about with the 200,000 acres net loss of wetlands, query if we know where that is. Is it little pieces here and there? Is it 1 acre here and there? Or is it big, large parcels? And I mean, any sense of that? And kind of a similar question to Mike. Mike, you talked about, what'd you say, 4,000 jurisdictional determinations that are kind of pending. Are those associated with fill permits or what? I mean, what are those associated with? What is driving those, and where are those locations?
We'll do the latter question first. So those 4,000 plus jurisdictional determinations that were pending post Sackett, when we had to go through and having valid regulation, and that was the process for the next 3+ months that we went through nationwide. They're in our 38 district offices across the country, and from that standpoint, large, small, all 404 dredge and fill permitting activities, which is our responsibility under the Act. So pretty broad distribution as I go out and visit. And so now we're working through, like I mentioned, 700 plus that we now clear the landscape, apply the new regulation, move forward with the jurisdictional determination, whether it's determining we have still jurisdiction over the activity that's in front of us, or whether we don't have jurisdiction. But it's interesting. I go out and I'm trying to ensure I get to all 38 districts, and in each district now, over the last couple of months that I've been to, we always have a session with the regulatory program folks, and they always tell me how many permits are pending now in my office waiting for resolution, because the reality is they're hearing from folks on a daily, weekly basis saying, when are you going to make a decision? When are you going to make a decision? And when am I going to get my permit? Or vice versa, you don't have jurisdiction here, so why don't you just tell me you don't have jurisdiction?
And those are lawyers making those decisions. I mean, they're lawyers and working with scientists, I guess, to make those decisions.
Yeah, and our regulators
Yeah.
are in charge of the program.
Thanks, Mike. That gave me time to look at the answer. And what I should have done is including the slides, the links to this report, and also so many, I'm sure, Mike, you feel this way too, so many amazing government reports and resources that probably are terribly underutilized by the public. And this is one of them. And so the short answer is there were losses sort of across the board geographically, but the vegetated wetlands category had the biggest loss, and the non-vegetated wetlands category had a slight increase, but that was obviously more than offset by the larger loss in vegetated wetlands. So any wetlands where there are obviously plants and trees and things. And that makes them, more valuable for the full range of ecosystem services. Also, my quick scan through the report, thank you, Fish and Wildlife Service, seems to yield that in terms of vegetative wetland losses, that applies across the board also to all the different categories. So riverine wetlands, freshwater wetlands, saltwater marsh, it seems like it's fairly all over the place and can't just be described as being in one geographic area or one type other than the vegetative wetlands type.
Thank you. All right, I'm going to ask one more and then I'm going to turn it over. So let others ask questions. And Sarah, you raised the idea of that the ESA is actually still a strong regulatory tool because if somebody takes an endangered species, I mean, I suppose if they filled wetlands that isn't covered by the WOTUS rule, they might take endangered species incidentally. And that's but that's a big stick, right? You go to jail if you violate the Endangered Species Act, right? It's not just like you didn't, I mean, getting a permit's one thing, going to jail is a different one. And so this really actually kind of increases the stakes in a negative way for people that harm wetlands, it seems like, potentially.
Yeah, it can. I think right. And so what we hope would happen is to avoid that uncertainty with potential criminal penalties that private landowners would use. The service has now a very sophisticated approach to getting incidental take coverage, it's called, for private landowners through Section 10. You can get a habitat conservation plan that allows you to do lots of creative things on the landscape. And so if you take a few endangered species and incidentally, you're protected, you're not subject to criminal prosecution. So there are sort of upfront things you can do to avoid the risk of prosecution. On the backside, I'll just say enforcement is not great. It's really hard to get the Justice Department to prosecute criminally for ESA violations. They're hard to investigate. They're hard to make the appropriate factual case for. I don't know if this is part of it. It wouldn't shock me if it's sort of unpopular to do because of the, all the issues the Supreme Court worried about in Sackett, right? Like notice, mens rea, all those things. So yes, it's super potent in theory on the back end. So we hope that there's just more proactive efforts for all the good citizens out there who don't want to, take endangered species by accident, to go through the regulatory process so they know where they are and what the best tools are to protect habitat and species when you're undertaking changes to the landscape.
And you can't say this, but the Fish and Wildlife Service never has nearly enough resources to do all the things it needs to do. And I'm sure criminal enforcement of the ESA is among the list of things that exist there. All right, we've got about 10 minutes left. Wally. There you go, it's on.
Mr. Carter, after Sackett, is the 1989 delineation manual still being used?
Those are details in our regulatory program that blissfully I am ignorant of, quite frankly. So that's a little farther down in the weeds than I get. The reality is if it has applying any of the concepts of significant nexus other than relatively permanent waters, continuous surface connection, it's not being used. Which is a big change because significant nexus was so broad that, what I'm finding out in the discussions I've had is we didn't do a lot of specific RPWs and CSCs types analysis because of the breadth of significant nexus, which was really the application that folks were looking at on the ground. And so now we're having to pull back and get back to those specific concepts that are still viable given the Sackett decision.
It was mentioned a few times in the context of Clean Water Act and protection of vital water resources. What kind of interagency coordination is going on between Interior, Army Corps, and EPA?
Well, overall, I can speak. There's so many areas where there is joint collaborative work being done amongst our agencies. and I'll just say as a threshold matter outside the Clean Water Act, I mean, that is whether it's permitting activity, whether it's strategically using federal resources, this is the area I think where we can build back in efficiencies into bureaucratic decision making, and we can demonstrate the value of the federal enterprise is when we're coordinated, when we're talking to each other, when we're out of our individual silos, and we're not blaming anything because it's easier to say, well, I can't do my work on that because they're, doing the ESA consultation right now. So I can't finalize my permit. It is the most people don't care. They don't care about EPA versus Army Corps or Interior. All they care is like, federal government, are you doing your job or you're not doing your job? So I'm a big proponent that, set aside differences, get to solutions, because that's what matters to the public. With respect to, on the clean waterfront, I'm in conversations every week these days with EPA about moving forward and how we're working with the Justice Department about responses to lawsuits now post Sackett and making sure we're all on the same page. We're now, getting into the details of continuous surface connection as it applies to jurisdictional determinations, and developing an agreed to approach moving forward. And then quite frankly, in a lot of different areas where we're working through permitting issues that we know are jurisdictional, we've got EPA on our side, side by side, trying to work through a number of those areas. I'll give an example, Salton Sea. There is a lot of activity in the Salton Sea in California. This is the sea that was created by a breach of flood control system on the Colorado River. It drained for several years into the basin, and now it's receding. But that's kind of just a sideshow to talk about. I like to refer to my reclamation days every once in a while. But a lot of critical activity going on there now, from geothermal production to now lithium extraction. And so there's a lot of proposals to move forward with lithium extraction, but there is a lot of wetlands in that area, and how we can, in an arid environment, find Sackett still jurisdictional. Even the companies are not debating jurisdiction right now. How do we move forward with permitting action? How do we get a new approach to mitigation? We'll try acre for acre, but there's a bigger concept here about stabilizing the Salton Sea, and working through those issues. That's going to require, intense coordination between Fish and Wildlife Service, EPA, and Army Corps, and we're just getting into that. That's just one example.
Really loud. So in Iowa, agriculture has a really big footprint in our land use, and I think it's fair to say that the agricultural community was very engaged in voicing opinions about WOTUS. And I think we might categorize some of those concerns as almost a little hyperbolic. Where are we at in terms of the impact of Sackett, WOTUS, on the decisions that everyday farmers in a state like Iowa are now needing to make? I mean, what's the impact there on the agriculture community from your vantage point of having to respond to this rule?
Well, I would argue that there is more clarity for the agricultural community just in the foundation of the exemptions that we specifically wrote into the rule, whether it was January 2023 or the retained exemptions that we included, the 8 exemptions in the conforming rule from September 2023. We listened to the agricultural community about ditches, about swales, and adding and prior converted cropland, that's still in place. That was an exemption before. That's an exemption. But we've got 8 exemptions because we listened, and we were trying at that point in time, as Administrator Regan and myself often said, is to have a durable rule and to take this out of the politics and the litigation that WOTUS has been in. And so we tried to build that durable rule. We tried to give more clarity. But then now I think We will ultimately have guidance that'll give detailed, broader context to continuous surface connection, which I really think is the question now. I mean, I'm seeing some assertions about rollback of reasonable, RPWs, relatively permanent waters, which I don't get, I don't think Sackett touched that. I'll just say that up front, but, continuous surface connection. So, but we will have jurisdictional determinations. And one of the things that my memo from March does is make clear we'll continue to post those. We will explain the basis for jurisdictional determinations. Hopefully that information will be disseminated. Some will say use it in the context of, hey, we need legislation to broad because this is a demonstration of our loss. And others will say, okay, that provides some guidance. So I think exemptions, jurisdictional determinations, transparency, that's going to provide clarity. And, the reality is that is more clear than significant nexus at this point in time.
Out west are far more complicated in the United States, but what your thoughts are about the role that you're play refuges and incentives to people that space.
You bet. So the question was basically, what's the role of the Fish and Wildlife Service in the eastern part of the United States? So much of the public land is in the western U.S., but we have the Fish and Wildlife Service in some places in the east.
Yeah, thanks. Good question. And I think it's really relevant for the wetlands topic, because a lot of our refuges are all over the country, including in the east, including here in Iowa. And the refuges managed by the Fish and Wildlife Service are in that portfolio of the third of the nation's lands. And they're not, they're not a big percentage, but they are lands that do a lot of work. They do a lot of ecological and environmental work. And they are also, and I know this because every time we promulgate a rule about hunting seasons on refuges, we get a lot of attention, right? They're very important to the members of the public who do know about them. And so maybe this is like, thanks for the question, because now I can do another ad for our refuge system, and say that it has its fans and its consistent supporters, but they tend to be in the fishing and hunting crowd, which is interesting. That's a great base of support for Interior. But there are also some conservation groups that know about and love our refuges, but they're not as well known because they're not, it's not Yosemite or Grand Canyon. You usually can't rock climb in a refuge. A lot of them are wet, they're squishy and wet. So that's just one example. And there are refuges in every state. And just to get back to Okefenokee for 1 second, that's, a huge, important resource that the Department of the Interior manages in the heart of the South. And now I'm going to get like crazily optimistic, but it also potential opportunity for true bipartisan support of conservation. Like the state of Georgia cares a lot about that, about the Okefenokee, for all the usual reasons, right? Including the ecosystem services reasons, huge tourism reasons, bipartisan support over the years. So I think there is that portfolio of lands. And also, by the way, some parks, a lot of things that people don't realize are national parks. Like most of Washington, D.C. is a national park, which is great, but also difficult for the city of D.C. sometimes. And they tend to be our more urban or historical parks, and certainly less acreage. But those are just the two examples, the refuge system, and then, the sort of more historical kinds of national parks that tell America's story. Are part of the presence of DOI in the East.
Can I just add my voice? I'm going to put on my former Interior hat because Sarah struck a chord there. National wildlife refuges are, in my view, equally crown jewels of our public land system. They are incredible habitats, incredible opportunities for people to recreate. They're next door in many cases now. We have more and more. urban refuges, and they are the most underfunded. And that's the point I wanted to make. They are incredibly underfunded, and they need everybody's advocacy because they're so important to so many communities. Just like, people don't realize the Army Corps with all of its recreation areas, we are adjacent to many, many urban communities. And Coralville Lake is an example here locally, an important resource. And just finally, getting back to Okefenokee, I just wanted to give a little bit of context because that's what my role at Interior made my antenna go up when I was hearing a lot about this mine on the border of the Okefenokee National Wildlife Refuge. So, it had tribal concerns because the Army Corps had not consulted with the tribes, who have a lot of historic tribes from their areas, and their historic occupancy in those areas have a lot of cultural resources at stake in any activity around near and around the Okefenokee. So, two factors. One, the navigable waters protection rule that had been promulgated during the Trump administration had been vacated by two district courts at the time in 2022, when I was looking at the jurisdictional determinations that had been issued by the Army Corps, which said we don't have jurisdiction. Based on that vacancy of the rule, plus the fact we hadn't done consultation, which we've now established we will do consultations on jurisdictional determinations, I rescinded that AJD. How do I put this? Probably not with the greatest foundation of record that has been issued by a federal administrative official. So when push came to shove, the Justice Department suggested I should build a better record when we were challenged on that. So that's on me. And then Sackett came. So we're back to kind of parameters similar to navigable. But that was the actions that would have led to a permitting decision had we redone a jurisdictional determination at that point in time, which would provide the permitting process that would have mitigated and provided additional protections to the Okefenokee National Wildlife Refuge. And that is no longer in case we're out of the picture with respect to that particular mining activity.
Well, great. I want to thank everybody. I want to thank the solicitor and the secretary for traveling all this way to be with us this morning. Please join me in thanking them. And second, I want to invite you to join us for lunch, and then we will be back in here. We resume at 12:45 for the next panel. And I want to thank everybody for coming out. It's so good to see everybody here. Thank you.
That's good.
All right. We're getting ready to start panel 2. I'll give you all a minute or two to find your seats. I'll go ahead and introduce myself while you're doing that. I'm Shannon Raisler. I'm a faculty member here at the College of Law and the faculty director of the Hubbell Environmental Law Initiative. We want to thank our generous sponsors, Fred and Charlotte Hubbell, again, for those who weren't with us this morning. The dean thanked them this morning, but they have made so many wonderful programs like this available to our community and the larger community, as well as supporting students in just numerous ways and enrich the academic experience around environmental, energy, and natural resources law here at the College of Law. So we thank them. My job today is to moderate the second panel, and I'm going to take just a little bit of time. I kind of decided to do this at the last minute, given what the first panel talked about, to transition us to the state responses panel. If you were with us this morning, you know that we heard from Secretary Connor and Deputy Solicitor Krakoff about the federal response. And we know what we're talking about, the Supreme Court's limiting of jurisdiction, but they really focused on ways that federal agencies are trying to use other tools to respond. But the state panel really will talk a bit about, well, what does this mean for states now that there is this regulatory void? I think we heard from Secretary Connor that about 70% of our jurisdiction over wetlands was lost after the Sackett decision. So if someone's going to step in and play the role of regulator, it'll be at the state level. So I will introduce our panelists in a moment. Given that it is the state panel, I thought I might start. I won't, Paul, I won't do too much of this because I know where he's headed. He'll tell you all about why wetlands are super important, but I just love this graphic. I use it in environmental law. It shows all of the wonderful ecosystem services that wetlands provide. And we heard some of that this morning: flood control, natural filtering of water, critical wildlife habitat, all kinds of important, we really can't put a price. We have put price tags on this, and we value the services of very big numbers, right? And as we heard this morning, we don't actually have to pay wetlands if we just let them do the work that they're designed to do. Because this is the state panel, I thought I'd show a couple pictures that are set here in Iowa. This is a wetland that was spared because it was between a set of railroad tracks. Another percentage or figure you heard this morning is sort of net wetland loss here in Iowa, quite large. 90 to 95% of our wetlands have been lost since European settlement, right? A lot of it converted to cropland. This is an example of what more of our landscape would look like had that not happened. And another point that I think you'll hear today is that restoration's possible. A lot of the watersheds surrounding Iowa's lakes contain drained wetland basins that are actually capable of being restored. So I think one of our panelists will talk more about that. So the reason we're here today is to talk about the effect of the Sackett decision on the definition of the waters of the United States. And I don't want to reiterate necessarily what was said this morning, but I do want to kind of put faces with the name in the case and talk just a bit about their property by way of illustrating kind of what this litigation was all about. So here are the Sacketts. They wanted to build a house on some property in Idaho near a lake called Priest Lake, one of the largest lakes in Idaho. And it just so happens that they were in a subdivision. Their property was undeveloped, but there were other houses around, right? And so this is an example of some of the wetlands in the area. They weren't right next to the lake. The wetlands had already been developed in other cases in this subdivision. So this was, prior to Sackett, a classic case of, well, is there a significant nexus, right, with the wetlands on the property and Priest Lake? And this is from the appendix in the case. You can see here how they began to fill in, right? This is another thing that came up today, that we're really talking about the Clean Water Act's 404 program, which is the program that regulates the dredge and fill of waters of the United States. And primarily that's a land development issue, right? We're not talking about building in a lake. We're usually talking about wetlands, right? Because wetlands look like they're somewhere between, right, land and water. And so we just love to fill them in and build on them, right? And use property in different ways. This is what the Sacketts wanted to do. Oh, I'm going the wrong way, sorry. On their property, when they heard from EPA and the Corps that maybe they should stop, right? And litigation ensued. As a result, the court took up the case. I don't like slides with a lot of words, but the words of this case are really pretty important. So just as background, right? This is the part of the case that as law students you highlight in preparation for class. It looks very much like a holding, right? We hold that the Clean Water Act extends to only those wetlands that are, as a practical matter, indistinguishable from waters of the United States. This requires the party asserting jurisdiction over adjacent wetlands to establish, first, that the adjacent body of water constitutes a water of the United States. So in the Sackett case, that was Priest Lake. That was a jurisdictional water body. And second, that the wetland has a continuous surface connection with that water, making it difficult to determine where the water ends and the wetland begins. And this is, if you're interested, when we usually post slides, this mirrors Justice Scalia's plurality opinion in the last case the Supreme Court decided. There's some debate about whether there's room here, but it's pretty close. Relatively permanent, standing, or continuously flowing bodies of water that are connected to a traditional navigable water, as well as wetlands with a continuous service connection. So I highlight this because, unlike this morning, we might hear some discussion at the state level that goes beyond wetlands and talks a bit about intermittent and ephemeral streams, because particularly in the arid West, right, water doesn't flow all the time, right? This test looks like it has a pretty big effect on those water bodies as well. So I thought it would be important, it might be important to just start there. I will end my I hope very brief intro here and introduce our panelists, who will talk for 10 or 15 minutes, I think we decided, and then we'll open it up for questions, right? So first, you have a long bio for all three to read, and I encourage you to do so. They're all really interesting people, but I'm just going to be brief in my intro. Paul Botts is President and Executive Director of the Wetlands Initiative since 2011, and this is headquartered in Chicago, pretty near to us. And he's going to talk about wetlands and their importance, and really bring it to the Midwest, right? And to some of our more regional geographical issues here in the Midwest. Christine Oblock is the Clean Water for All's Clean Water for All's Protect Our Waters campaign. You lead this, right? Are you the president of the campaign? You have a title? Okay. She leads the campaign. So she can speak to what's happening across the country in the different states, particularly Colorado, but others as well, in moving forward. Incidentally, a lot of states were not big fans of rolling back jurisdiction. There were some that wanted more limited federal jurisdiction, but states like Colorado filed amicus briefs in Sackett and said, we don't want you to roll back federal jurisdiction because we we need you, right? We need what the Army Corps does here in Colorado. And so now, of course, they're left without federal jurisdiction and trying to decide how to move forward. And last but not least, David McKellis is the Illinois Legislative Director at the Environmental Law and Policy Center, working on these issues currently, right, before the Illinois legislature is going to talk about initiatives there. We think Illinois is a really interesting case because it did not have protections on the books like some other neighbors of ours, like Minnesota and Wisconsin. And it also has some of the same interests that Iowa has, namely agriculture, right? So thinking through how we might address these issues at the state level, we thought Illinois would be a good case study. All right, so without further ado, should I turn it over to you, Paul? Let me be like me and move forward rather than back.
Oh, yeah. Well, thank you. It's good to be here. Before I start, a quick addendum about the language that was just on the screen. It's important to note that that language is from the 5-4 portion of the Sackett ruling. The court had already ruled unanimously 9-0 in the Sackett's favor in the specific instance before them. So now there are probably people in this room who can be part of the solution of untangling the specific meaning of the 2-part Supreme Court ruling. I sure can't. But it does appear that that continuous surface connection test was not necessary in order to rule in the Sackett's favor, which is of great interest and concern to us at the Wetlands Initiative because that gets to quote unquote isolated wetlands. And they did not explain that. The 9-0 part of the ruling literally received zero explanation in the majority ruling or any of the concurrences, which leaves us kind of at sea on that point, quite frankly. However, we're going to talk hopefully about a little bit more. Okay, so, and this is telling me what I see. All right, yes, so the Wetlands Initiative is 25 years old. We're a regional nonprofit. We started out with a relatively narrow mission, which has broadened a little bit, but we're still pretty close to what we started at. This is our mission statement. We're in the restoration business. That's the core of what we do. Is we're the people to go into the sort of the hard places where you would look at and say, I'm not even sure you could restore that to a wetland. Our reason we exist as a nonprofit is to both design, but also do the case that you can. And it ends up with a lot of beautiful places like this. We have so far worked entirely in Illinois and Northwest Indiana. We are exploring some possibilities in some of our neighboring states, but we're very much a Midwestern centered organization. And that's what I'm going to mainly talk to you about here today. So why do we care about wetlands at the very top level? And you've already heard about some of this. Clearly, I saw the very nice graphic up there. And you see all this. And I want to emphasize, though, this third point here, which is relatively new in a way, of course, as we all know. And what I always say is that our climate is already changing, has in fact already changed, is changing around us. And in the Midwest, we know this very well because we're all living it, because our storm systems are bigger and heavier and more weird in their timings in the course of the year. Our rivers, as the engineers say, are flashy at weird times now that they're not supposed to be flashy. And even our gray infrastructure is trying to keep them from having flood stages in October and weird stuff like that. That's normal now. And in that context, wetlands, which are natural sponges, we were left and walked into, even before Europeans, the first human beings that came into the Americas 15, 20,000 years ago, ice sheets are retreating. And what are they seeing behind? A landscape covered in natural sponges. And in the context of a changing climate, dumping more water in bigger gulps on our developed human working landscape, having natural sponges is a huge asset. They can hold water and then gradually release it, just like a sponge that you have in your kitchen. How does the public view wetlands? Happy to say there's been some change on this during my professional career, but still the fundamentals are, depends who you ask and when. One person's beautiful spot can be another person's mosquito factory. We get that all the time. When we go to do wetlands restoration someplace, we do community meetings. One of the first things I always get is, "Did you guys making a mosquito farm?" "Well, no." And when we explain, we talk about that. This is one that is very real, very salient in the Chicago area, but really any area with relatively dense, especially a lot of suburban development or urban, it can be either one. We have terrible flooding issues in the city of Chicago. Our infrastructure is kind of overwhelmed in that way. But flooded basements make people crazy. And I had a very wise individuals with one of our county forest preserve districts out in one of our big, heavily developed county suburban belt. We were designing a restoration of a certain stream. It was going to go right by some, established subdivisions and so forth. And he said to us, now, you guys need to understand something. You, of course, need to make sure that what we do here doesn't end up flooding anybody's basements. Duh. But you also need to make sure it doesn't look or sound for one moment like you might ever flood a basement, because flooded basements make people crazy. And wetlands inherently, to the average person, look like a problem, a cause, not a solution. What are you doing? You're bringing water back next to my basement. Whoa. That's what we get. And then a particular thing that's very salient in our great Midwestern farm belt is the reaction. I'm going to come back to this because it gets to some things actually, even in the Sackett ruling itself, but in the state responses of the Sackett ruling, I'm going to touch on this. Some owners of working lands fear that having a wetland on their land, especially some person from outside discovering a wetland on their land, is a path to effectively having their land taken away from them. That's how they feel. That's what they say. And some of our partisan media has spent a quarter century drilling that message home as the threat statement that leads to a ruling like Sackett. This is one of the things we have to deal with in the Midwest. Good news, general public perceptions of wetlands. You take polls, you cross the country, you interact with people, have been shifting in the positive direction, particularly with younger generations, but also with audiences like hunters and anglers. There is more awareness in a lot of the American public and more affection for and interest in wetlands. The people who have been at the Wetlands Initiative on board or staff longer than I have talk about this as a difference just in our organization's lifetime as an organization. It's a question we get all the time. What qualifies as a wetland exactly? And this gets very political right now. So it's important to have the right answer to. The correct answer is it's a piece of ground that is wet much or all of the time and long enough and regularly enough that it contains plant and insect and microorganisms and animal species which evolved for those conditions, depend upon the wetness. And it has to be long enough and regularly enough that the soil chemistry has been changed. And those words, long enough and regularly enough, are bolded for a reason. Simply becoming wet does not a wetland make. I literally got this, as David will remember, when we were testifying in an Illinois state legislature hearing about the wetland bill that he's going to tell you all about. Digging a drainage ditch does not instantly create a wetland, jurisdictional wetland. Having a big pothole get filled by a rainstorm, you have not created a wetland. We get phone calls in our office actually on both sides of this. We get people calling with the concern, are you guys going to come take my whatever piece of ground, my yard, whatever it is? But I also have gotten the opposite phone call of, hey, look, we have a wetland now. Yeah, not from a legal perspective or even a technical perspective. No, you don't. And now the soil chemistry aspect is interesting. That has changed our work and the work of all our peers in the last, let's say, professional generation, because it has become settled science, settled engineering knowledge that the wetland, an actual wetland for a long time, changes the soil chemistry in a lasting way. Now, soil chemistry in the real world doesn't shift instantly. It doesn't shift from one rainstorm or whatever. And it also doesn't shift back instantly. So what this means is we have effectively a fingerprint on the ground, in the ground, which is that and there's engineering firms all over the world that do this now. It's standard practice. Very simple test. You only have to go down a couple of feet. It's very easy to recognize hydric soil if you've graduated from any kind of civil engineering school or whatever. And you effectively have a fingerprint. This has been a wetland. Now, soils in the real world, mix. It's not all exactly the same kind of soil in a given spot, but where there's a predominance of hydric soils, we know that used to be a wetland, and we know it used to be a wetland for a very long time and on a very regular basis. Otherwise, that soil chemistry wouldn't have changed. And that leads us to this. I get this all the time, in Chicago, and many people in Chicago who grew up in the Midwest, and there's many people in Chicago who are from other parts of the country. And The Midwest broadly in the public mind is not associated with a lot of wetlands. You know, you say wetlands, people who aren't in our line of work, they're thinking of the Everglades, they're thinking of, you know, the lost grand swamps, et cetera, et cetera. Actually, wetlands originally made up a great deal more of our flat Midwest than most people today realize. So here's a couple of graphics. Well, I'm getting into the graphics. A healthy prairie landscape, first of all, we're the great tall grass prairie region, right? Healthy prairie landscape is not separate from wetlands, but rather is threaded with and depends upon wetlands of many types and sizes. So I went to public schools. The school book sort of image you'd have is the great mountains are over there, the big northern forests are over there, and the big swamps are over there. Three separate things. Yeah, not so much, at least not the forests and the prairie. Threaded with wetlands, and that's inherently true in nature. And the flat Midwest still is to some degree, quite rich in rivers and streams, much richer in rivers and streams than people from other parts of the country have any idea. And those rivers and streams were originally slower. It's very flat. And as our engineers and ecologists say, connected to their floodplain, meaning not incised down, not big, heavy banks. When it floods, it's flat, everything spreads out, big, wide floodplains. And also in nature, our flat, slow Midwestern streams moved around a lot, up to and including the Mississippi. Mississippi before the 19th century moved all the time. They have good records. There's a really cool map done a long time ago by Army Corps of Engineers people showing the many different channels of the Mississippi. About 2/3 of the Illinois River goes down the middle of Illinois, was the Mississippi a couple thousand years ago. Our rivers, big, small, medium, moved around constantly, and of course, created wetlands, but also moved the wetlands. So this leads to, prior to the 19th century, between 1/4 and 1/3 of that vast tall grass prairie region across about 10 states was wetland. That's a lot of land. That's a lot of wetland. That's a heck of a lot bigger than all the Okefenokes put together. And here's a couple of maps. This is using that hydric soil concept. This is that fingerprint. So I brought Illinois and Iowa. And as you can see, all that blue is lands that are at 50% or more, in some places all the way up to 100%, hydric soils. So this means that those are areas, all that blue, and if you zoom in, it's going to be many, many threads and dots of wetland. You can also see on this map where there wasn't nearly as much wetland. You look at the white areas. So if you look at the northeastern part of Iowa and the northwestern part of Illinois, that's the driftless region, which geologically is a whole different thing, not flat, didn't have the moving streams, didn't have the water sitting for a long time creating wetlands for several millennia. The punchline is this. Today, about 1/4 of both Illinois and Iowa, so a combined 28,000 square miles, 9 million acres if you're counting, is predominantly hydric soils. So you're talking, that's the part of our region that was, for several millennia since the last ice age, wetland. At least most of the time for a very long time. And nearly 90% of that area, of all the blue you see in these two state maps, is no longer functioning as wetland. Actually, the slide should say. So it's been filled, ditched, all those things. Why do Midwestern states today have small fractions of their original wetlands? Well, of course, we know one big reason is the world's most productive agricultural region now. And it now comes with a growing underground system of water removal pipes called field tiles. I'm sure most people in this room know what a field tile is. It's a very ancient technology. The Romans built field tiles. So did the first settlers in New England and so forth. But it was a niche technology until the Midwest. Flat, wide, great farmland, but the water doesn't move off it very much. The perfect solution to that turns out to be field tiles. There are now millions and millions of lines of these underground, gradual, gentle pipes draining our millions and millions of acres of beautiful black soil farmland and draining the wetlands. Most of our rivers are no longer allowed to move around the way they were in nature for thousands of years. They've been straightened, they've been leveed, confined. or altered in other ways, which stops them from shifting around and separates them from their floodplains. Like, we put lots and lots of money and effort into separating them from their floodplains because we have this idea that if we just confine the river, big storms come, all the floodwater will just sloosh away and be somebody else's problem. Doesn't actually work so good, or at least not as well as we'd hope, but that's the basis. And then the other thing worth noting is in the grand scheme of things, our particular part of what's called the developed world developed in a blink. Our part of the world, compared to, let's say, Europe or the eastern half of the United, or eastern third of the United States, went from no, again, in the modern tech, use of the word, developed world, went from 0 to 60 in about 5 or 6 human generations. That's incredibly fast. And the reason, or a reason we were able to do that, was it happened to be the time period when all these mechanized construction things, tools were being invented, starting with steam shovels, but then later other things. So that greatly sped up the process of developing our part of the world in that sense. And that meant it sped up, in large part, the filling and draining of wetlands to build our cities, towns, railroads, industry, and highways. And then a subset of that is that modern large-scale engineering to ensure public hearing at modern population densities. Chicago has little less than 3 million people now, and isn't even one of the, 50 or 100 biggest cities in the world. But it was 100 years ago, and just 200 years ago, it would have been like the second biggest city in the world. So the population numbers have forced us to do things for public health purposes, which has, as one of their consequence, a lot of wetlands being either degraded or destroyed. Now, this gets to the legal part. No net loss wetlands permit programs, such as the Section 404 federal program, such as you're going to hear about what we're trying to get created in Illinois. They are a mix of protection and restoration. That is to say, mitigation banks. So a person want to develop their land, want to fill it in. They're either going to be, depending on the quality of the wetland and some other variables, going to be really encouraged not to do that and maybe build around it, or they're going to have to buy mitigation credits, which means someone else at a mitigation bank in the same watershed is restoring wetlands. The science and practice of restoring wetlands has come a long way. We've proven how effective it can be, and my organization is proving how it can be done even in difficult places. But still, a couple things to know. It's not a slam dunk. It can be done badly without much effort, believe me. Restoring wetlands is inherently more complex than restoring some other natural communities, prairie, savanna, other things, because of the water. You need deep skills, not just in ecology, but in engineering. So my organization, our project team is led by a PhD engineer and a PhD ecologist and their peers. And that's by design because of what we do. Wetlands are resilient. This is good news. And restoring them is not all or nothing. Wetlands function can be improved or restored to various levels of completeness or scale to fit local conditions and priorities. That's really important, because that brings the possibility of restoration into more places, and it makes mitigation banks, on paper at least, more workable and more worth doing, this factor here. This is my standard closing slide, which I like just because of the picture. I know we're going to do questions later, though. So what I'm going to now do is turn it over to Christine Oblock, who is going to, as mentioned, talk about the national picture of the taking this into the states. And then you're going to hear more about our case in particular in Illinois from David. And I'm not sure what to do. Oh, there we go.
Excellent. All right. Thanks everyone for being here. I'm going to go ahead and get into the first slide. Yeah, thanks everyone for being here, for joining online, especially after lunch on a Friday. Very excited to see you all here. I'm very excited to talk about wetlands, and it's not often that we get to share that enthusiasm. So I'm glad that you all are here for that. As Paul said, wetlands are incredibly valuable hydrologic features. And you heard this morning and just now, and I'm sure you guys all know that they were dramatically impacted by the Supreme Court decision in Sackett versus EPA last May. I'm, as Paul said, going to talk a little bit more about what that means for states and how states are responding. But first, let me tell you a little bit about myself and our organization. So I'm Christine Oblock, Protect Our Waters Senior Campaign Manager, although I like President. That was, yeah. I know this is a good promotion on the spot. I like it. And I work with the Clean Water for All Coalition. So Clean Water for All Coalition is a coalition of over 100 member organizations ranging from local water keepers, hyper localized, to national environmental organizations, all with the combined commitment to advocating for clean water for all, as you'd imagine. And that between all of our organizations, we have a reach of over 15 million members across the country. Our coalition priorities are to focus on policy solutions aimed at the main threats to our surface waters. We consider that to be the threat of runoff or non-point source pollution, the lack of investment in equitable, affordable water infrastructure, which harms both people and the environment, and threats to the Clean Water Act. And obviously, this conversation fits solidly in that last bucket of work. So as has been discussed and already shared many times, on May 25th of last year, the U.S. Supreme Court handed down its decision in the landmark environmental case Sackett versus EPA, which concerns which waters are protected under the Clean Water Act. In the case, the operators of it, so we got to see a picture of the Sacketts earlier, but I think it's also important to point out that they own an excavation company, so they should have known. But they sought to eliminate Clean Water Act protections for vast swaths of wetlands in the country. And unfortunately, as we know, they succeeded. I just want to take a minute to highlight that the real world implications of this decision are enormous. I think we've heard a lot of them throughout the day from different perspectives, but I think it's worth just spending a little minute to reiterate them. So the court's rationale in this decision was very similar to the basis of a regulation that was adopted by the Trump administration, the Navigable Waters Protection Rule, which was estimated to eliminate federal protections for more than half of the country's wetlands. So in the very short period when that regulation was implemented before being struck down by 2 federal courts, the federal government applied the rule to exclude more than 19,000 wetlands from Clean Water Act protection. So in a very short time, it illustrated the impact of that decision. To make matters worse, this decision has come against a backdrop of significant degradation. The nation had, before the Clean Water Act, lost much of the wetlands. We've heard a few different numbers of what that means here in Iowa and across the country. But between the time of European colonization and the 1980s, an estimated 53% of the wetlands in the continental US were destroyed. And we got to hear a little bit about the fabulous recent report from the Fish and Wildlife Service about the wetland status and trends. So I won't belabor it because I know that folks were paying attention and heard that earlier, but I do want to just highlight one piece of it that I think is particularly important, which is that they found that between 2009 and 2019, wetlands loss increased by more than 50% from the previous study, which covered 2004 to 2009. So that means that even without the limitations of the Sackett decision, and the resulting limitation in protections, we're losing wetlands at just a staggering rate. I also think it's important to point out that, as is often the case, it is still Black, Indigenous, and people of color and low-income communities who are going to be most impacted by this loss of protection. And although the case focused on wetlands, as we talked about, it also impacts more than 1 million miles of rain-dependent streams and perhaps even more than 500,000 miles of seasonal streams. So we'll definitely talk about that more, but right now, we're going to focus on what this means in the states. So this is where we get to the exciting part. With this loss of protection, the burden of protecting our waters is falling to the states. So states have different existing regulations and laws. They have different processes, different threats, different hydrology. And so since this map was created in the direct aftermath of the decision. You'll notice a lot has changed actually in this map since it was created about a year ago. You'll notice that this map in particular is focused on the impacts to wetlands. So it was created before the EPA issued their adjusted rule, which more explicitly includes streams. So at the time, we weren't sure exactly what the implications would be. So we did a lot of our analysis based on what we did know, which was that wetlands were excluded, and then kind of looked at what we thought might be the implication for streams. Now we know that it's a little bit more clear that there will be a significant impact. And as has also been stated, that will most dramatically impact the arid West. So that's the area. There are a few states on here who I think once we included the streams will be much more in that like bright red category. So for this map, they looked at which states have state dredge and fill programs, as well as the amount of wetlands in the state. They also looked at the statutory regulations that determine the threat to those wetlands with the limited protections under the federal permitting system. So since this map was created, many states have also changed their, not only is the scope of what we know to be the loss of protections to be, but not only has that changed, but also some of the states have taken action since the decision. And so the landscape is a little bit different. So in some states, as we've mentioned, we are working on increasing and setting up programs through the legislative process. So right now that's Colorado and Illinois. Some are working on allocating funds to cover the gap in costs from a reduction in federal scope. So Washington just recently passed $2 million in their appropriations process to help support this. There's a similar bill in California right now. This is slightly different, but the New Mexico also in their short abbreviated legislative session this cycle passed $7.6 million to set up a program. For them, they have to do both surface water and wetlands. So it's a heavy lift, but these are places where they're really using that like budget allocation to address the loss of the federal scope. And then some are using executive order to increase protections. So North Carolina just did this recently. And some either have already rolled back or in the process of rolling back protections that would have filled the gap in protections left by this decision. So David's going to talk a little bit more about what that means in Illinois and our efforts there to fill this gap in protections. But I want to point out the difference in response from Illinois' neighbor, Indiana. So for 200 miles, the Wabash River forms the border between Illinois and Indiana. You can see it at that like very bottom section. On the Illinois side, lawmakers are working to pass a bill that would protect wetlands from development and pollution in order to safeguard water quality and limit flooding, like Paul just talked about. But in Indiana, legislators pushed through and passed, I mean, in record time, like pushed through in like just a staggeringly fast process, a law that would roll back wetlands regulations. So that means that water that flows into the Wabash River from one side of the river could soon be governed by, hopefully, will be governed by very different laws and standards on one side than it will on the watershed on its eastern side. So, as we know, that doesn't work. As a reminder, water doesn't recognize state borders. By reducing protections at the national level, states are left creating this like patchwork of protections. And after all that work, they're still at the mercy of their neighboring and upriver states. So I'm from Colorado. I was excited to see how much Colorado representation we had here today. Was not expecting that. Out there, as we've talked about, it is the arid West. So every drop of water is precious to us out there. But we don't have a state program as of yet to protect our wetlands and streams from dredge and fill activities, which means that our headwaters are at risk to development. But that also means that Arizona and California and Nevada are also at risk for the development that can now happen in Colorado. I want to share be sure to let you guys know that we have some recent polling that demonstrates how supportive the public is particularly for passing federal protections. So 94% of Americans say that protecting the water in our nation's lakes, streams, and rivers is important. In addition to this, a majority of voters think that the federal government and not the state government should be responsible for establishing standards to protect certain waters and wetlands from pollution and development. Of that, a bipartisan majority of voters, so 83% of those who were polled, would want their state legislature to support a law to restore protections to their state wetlands and waters. So I'm going to pass it over to David to talk a little bit more about what that means for Illinois and in the state. But I did just want to restate one more time that out of all of this, like it's so valuable for these waters to be protected, and that needs to be done through consistent science-based federal protections if we want them to actually work. The burden for states is just so high, and many of them are just not able to do it. And we really need that federal backstop in order for it to work. So I'm excited to talk about what we can do in the states, but I just want to make sure that we're clear that we need the federal action.
That's right. Thank you very much, Christine. Thank you all for being here. And before I started, I did want to follow up on something that Sarah Krakoff said earlier. And I come from working in Illinois state government before working at ELPC. And along with work in the federal government, working at state government levels is incredibly important. And what we've seen in Illinois is a massive drain of knowledgeable employees at the state level whether it's at our EPA or DNR, due to either retirements or people just getting fed up with the process and saying, I'm out of here and I don't want to do this anymore. But it's incredibly important. And so, especially for law students, considering that, and also as of right now, there's public service loan forgiveness, and my wife and I have both taken advantage of that. And I can tell you, it is well worth it. If you are a law student, you know about the debt that can come along with that. So David McEllis, I'm the Illinois Legislative Director for the Environmental Law and Policy Center. Uh-oh, I may have lost my map. All right. I think you can barely see the light background. You can see a light line of ELPC's regional footprint here, but you can guess. You got the state names on there. So ELPC is a Midwestern-centric environmental organization where we have our headquarters in Chicago, but we also have offices throughout the Midwest. And when we have attorneys, policy analysts, lobbyists, and communications professionals all working on environmental issues, either at the state houses, at public utilities commissions, or in the courts throughout these states. When the Sackett decision came down last year, we looked at the map that Christine had earlier, and then we looked at our own map, but it was filled in. And we looked for places where there were opportunities to do something on wetlands protections. What states have functioning programs? What states don't have functioning programs? What states have governments that might actually be interested in moving forward with legislation rather than rolling back existing legislation? So of those that didn't have programs, Illinois was a key outlier. Iowa doesn't have one, but we weren't sure that it was a possibility at the State House. I'm looking at Steve to give me a nod here. But in Illinois, we have both supermajorities of Democrats in the House and Senate, as well as a Democratic governor's office who is interested in doing things that are of a national significance. So Illinois has had no standalone state wetland program. We've had 90% loss of wetlands since we became a state in 1818. And the only existing wetland protections are through the Interagency Wetland Protection Act, which says to state agencies, try your best to have no net loss of wetlands. And some agencies are better at that than others. But there wasn't a overarching wetlands program. Some of the counties have programs. Cook County, where Chicago is located, along with a lot of the suburban counties, have existing wetlands protections and wetland programs. So, but the rest of the state, everything south of I-80, has no protections. There's a lot of wetlands on that map that Paul showed that have no protection as isolated wetlands after the Sackett decision. So ELPC and other organizations like the Wetlands Initiative, the Nature Conservancy, Illinois Environmental Council, and other members of the Clean Water for All campaign got together and discussed what we can do at the state level in Illinois. And we also met with legislative leadership because in recent years, when the Supreme Court has made adverse decisions, the state of Illinois has been, in some cases, likely to step up and say, this is a bad decision, we're going to pass a law. They did that with Dobbs, with the Dobbs decision to pass state laws to protect abortion care. So we went to legislative leadership and said, here's another case where the Supreme Court messed it up. Will Illinois step up? And we got a decent response from that. one would expect with super majorities in both chambers and a Democratic governor's office, maybe we could get a wholehearted go for it. But there are still some moderate voices who are amenable to farming interests as well as business interests who are pushing back against new wetlands protection, and people who supported the Sackett decision when it came down. So we got a little bit of a go ahead to try to put a Band-Aid on an open wound. So in recent years, we've passed some good environmental legislation, but we've also seen some other stuff get held up by business voices pushing back against it. And so we're moving forward with a little bit of caution. When we discussed the direction that we would go, we wanted to make sure that we had a good foundation of some legislative principles to know what we're pushing for and to know kind of what is a good win for the state of Illinois on this. And for that reason, you know, for the reasons I suggested earlier, we wanted to come up with something that could be reasonably and realistically defined as a direct response to the Sackett decision. So we wanted to create a state wetlands protection program run by the Illinois Department of Natural Resources, prioritizing avoidance of impact to wetlands, rivers, and streams, and also requiring a compensatory mitigation program and making sure that that program is well run, that there is funding for it, and robust enforcement. We also wanted to make sure that we have a citizen suit provision. So if somebody sees something going wrong, if someone sees someone breaking the law, that they can stand in the shoes of the government and file a complaint with the Illinois Pollution Control Board. So we also wanted to make sure that there is clear direction to the regulated entities and that this isn't creating an undue burden that is unmeetable and unworkable for both the administrative at the administrative level for DNR as well as for landowners. And what we found was that in a lot of cases, people liked the county programs and felt that the county programs gave them some certainty when they were trying to develop it. So we also didn't want to mess with the good running county programs in Cook County as well as the suburbs. We also kept in exemptions for farming activities. So arguments against a state wetlands program, there's a farming exemption. If someone is doing farm work, that is an exempted activity. And so we put together a bill starting from these principles. And we found that when we talked to people about it, there was a lot of support. And so what we have here is the bill status for both our House bill and Senate bill. We introduced a version of the same bill in both the House and Senate. We have over 20 co-sponsors in the Senate, 22, I believe, and over, I think, 35 in the House. We need to get 30 votes in the Senate and 60 votes in the House to pass a bill. So we're pretty close to 30 co-sponsors just in the Senate, and we feel pretty good about where we're at. And partially having the experience of folks having voted on bills addressing Supreme Court decisions in recent years, when we go up to legislators and say, this is in response to a Supreme Court decision, they'd say, okay, where do I sign up? Because they know what that means, and they know that what that means is probably something detrimental. Both of these bills have passed out of their respective committees, and they are now waiting for an amendment. That amendment will hopefully bring the Illinois Department of Natural Resources on board. We wanted to make sure that we have a program that the Department of Natural Resources believes that they can run and that they are on board with actually running it. And we'd like them as a willing partner in this to go forward and do a good job. So some of those next steps, we've had conversations, some of the next steps on this, we've had conversations with DNR, with the Illinois Environmental Protection Agency, with some of the county authorities, hunting and sporting groups to try to get support. And I think that we have some support from hunters and sportsmen on this as well. And we have to bring an amendment back before a committee. So Paul and I might be testifying in committee again next week in support of this bill. And then next week, there's also a Senate deadline to get a bill out of the Senate. So hopefully by a week from today, we will have a bill that has moved through one of the chambers of the Illinois legislature on its way to the second chamber and then to the governor's office. And so in the next, there's 7 weeks left of the Illinois legislative session. It normally ends in late May, right around May 31st is when the constitutional deadline is. So we hope that by May 31st, we will have a bill that is ready to be signed and a new Wetlands Protection Act that has never been implemented in the state will be law. So one of those two that you said, hopefully we get to knock that out. I will move on. Thank you.
All right. Well, first, I just want to thank the three of you for really wonderful presentations and doing such a nice job complimenting each other. It's just spectacular. So I'm going to open it up now for questions because we don't have a ton of time. I will not not exercise the moderator's privilege and ask mine, but instead ask you to kind of raise your hand, and I will repeat your question for the recording because I understand it's not picked up by the microphone. So just speak loudly if you would. Does anybody have a question? Oh, yes, Jim. Thank you. So to sum up, the question is about drainage laws, which I believe give local authorities a lot of control over drainage and wetlands. And to what extent have you seen that outside of Iowa? Or how pervasive is that?
Yeah, I believe the question was specifically about a thing called drainage districts, which is a local special purpose district that can be formed actually by local landowners, can band together. It doesn't even require like a county or city or village to do it. We have those in Illinois from the same era, very similar laws. And there are some other states in the country where you have, big rivers going through agricultural areas. And as I mentioned, the rivers, are flat and have wide floodplains. And basically, they realized in the late 19th century that unless farmers were able to sort of band together and form an authority and share the cost of draining and building levees and so forth, they never be able to farm it effectively. My organization actually owns such a place now, which was subject to a drainage district. It's a relatively bespoke thing. It doesn't cover, there aren't drainage districts all over our states. It's mostly along the rivers. But they they mostly exist already. So I do not believe that our state law that we're trying to put in place certainly wouldn't, eliminate the drainage district law, but there isn't actually much going on anymore of forming new drainage districts. It mostly was done. There are cases here and there of drainage districts being dissolved, which is also called for in our state laws. But basically drainage districts and the levied off agricultural chunks that, are the reason they exist are basically a fact on the ground at this point. They're not going to be undone by a law. Yeah, they weren't undone by the Federal Clean Water Act. They're not going to be undone by a state law either. But they're also not a thing that is particularly growing. It is certainly not cheap or easy to band together and spend private money to build a whole bunch of levees and pumps and so forth, which is what a drainage district enables. The drainage district is collecting its money from the landowner, so it's not a general taxing district. So the fundamental economics of spending all that money to build fresh levees and big fancy pumps to drain big chunks of floodplain alongside of a river haven't changed. It's just the drainage districts are there So I don't think that either I know that the Clean Water Act 404 program didn't particularly change that reality, good, bad, or indifferent. And I don't think our state law will either.
Okay, just one second, sorry. So I'm going to repeat the question. This is a question about agricultural exemptions. We heard this morning that those are, they have long been in federal law, but the question now is about Illinois' law and state laws generally.
Yeah, so that exemption exists for, I believe, for existing farmland versus bringing new farmland into creation. But I think that the way that this act would create new wetlands would be through when you're taking through the mitigation requirements, when you're taking a wetland out of service and filling it in, then we're replacing it through one of those mitigation banks. But I believe that the exemption is for taking non-farmland and turning it into farmland.
So the fundamental is that farming activities, and I want to emphasize this, farming activities, which is not exactly the same as saying farmers, right? Because as a landowner, but farming has been exempt from the Clean Water Act from the beginning. Always has been. And you can view that a couple different ways. A more theoretical way is to say that it's just part of life's trade-offs. And certainly in the discussion of the original Clean Water Act in the 70s, it was that was the language used. Said the wetlands are important, our waterways need to be clean and so forth. We also all need to eat, fundamentally was the political discussion. These are political acts. The fundamental is that the Clean Water Act, through all its different updates through the years, has never lost that exemption, a blanket exemption. And my personal view is it never is going to and never would as long as every state has 2 senators, plain and simple. Now in Illinois at the state level, as part of the practical politics of passing a bill that would work, that in our very farm sense, 75% of all the land in Illinois is privately owned farmland. Right. And so anybody can do the political math on that. So I think David would agree, we have 0 chance of getting this program established in Illinois unless the exemption that everybody's used to from federal law carried into this program, plain and simple. Now, there are other things though, and we get this question. I know you have. I've gotten this question because we work with farmers. We have farm constituents. We're doing constructed wetlands on farm right now. So just in the last week, I've had some really rich conversations. Our staff has too, with a couple of our farmer partners. So there are other programs. There's a federal program under the Department of Agriculture called Swamp Buster, which places some limits on what farmers can do with regard to filling in or farming wetlands. That is completely outside of the Clean Water Act. It's not affected by the Sackett ruling. It has nothing to do with our state law. It's not changing good, bad, or indifferent, and there's different opinions about how effective it is. But that's a different piece of law based on a different political calculation. In terms of the fundamental of farming being exempt from this kind of program and this mitigation requirement that David just described, that, as far as we can tell, is a political third rail and has been since the invention of our Federal Clean Water Act.
The one thing I would add to that is that I think when we get opposition on this legislation, one of the first things I raise is our intent here is to put back in what we had prior to May 2023. And that was kind of the direction that we got, which was put a Band-Aid on it. Is there a way to do a stopgap? And so one of the ways that I point out that that's what we intend to do here is that we kept all of the same exemptions from existing law. And we said, if you were required to do something in January of 2023, that's what we're trying to do. If you weren't regulated then, don't expect to be regulated now. If you were regulated then, expect to be regulated under this act.
Okay, now I am going to exercise the moderator's privilege because I want to just ask a follow-up and see if Christine has anything more to add. Are you seeing, we're familiar with objections from agricultural interests here in the Midwest. What are some of the other objections you're hearing in states like Colorado and other places?
Yeah, it's not exactly unique. Like so far, agriculture is definitely one of the main oppositions across the country. Developers, particularly in Indiana, home builders were very instrumental in pushing the legislation through there that removed protections. In Colorado, we're seeing a lot of similar kind of sentiments. So in addition, I would add like sand and gravel and oil and gas, but I would just generally frame that as like the regulated community. The regulated community would like less regulations, and those of us who are using and depending on the water agree, but according to polling, that we need more of them. So that tends to be just like that tension exists everywhere. We have worked with a lot of local ranchers and farmers in the West who are very committed to they like the regulations because it ensures that they have guaranteed water. Like I said, if we develop on wetlands in the West, that decreases our flow. Like that means that we have less water, and farmers very much understand, and ranchers understand, that we need that water. So I don't think it's fair to paint with like a big brush and say that all of the regulated community does not agree with this. There are certainly entities within that community who are supportive of this, but it does tend to be the same kind of opposition that comes up in all of the states. And I would say that, like, just like what David said, that our biggest opposition to I think if we could give Paul free rein and write like what would the Clean Water Act look like and how would we protect wetlands, it would be very different than the bills that we're putting forward, because our biggest opposition to creating that like dream protection is a desire to maintain a status quo and to maintain that balance, like you said, between the like food production and home building and the actual like preservation of these really precious resources. So it's a tightrope that we've been walking for a long time, and I think we'll have to continue to do.
Well, and you know, Christine, your comments remind me of something. David, I'm being reminded now of the call that we were on with a couple others, and you referenced it actually just Monday of this week as the call that creates our optimism that we're going to get some support, maybe even a couple of endorsements from the outdoor recreational community, hunting groups, angling groups, and it's a lot of farm membership and so forth, some of the same folks. And to the one wrinkle that maybe shifts within that range of there's the absolutely over my dead body all the way to we support this, and then there's folks in the middle who just have questions from those communities. The guy who was the head of a statewide federation of outdoor groups in Illinois, after talking with us, he got his questions answered. He was feeling pretty good. I think they might endorse the bill. And he commented, he volunteered that some of his members, board members and members of his organizations, are going to be, depending on how you put it, I guess I'll put it as less uncomfortable with a state level law than they are generally about stuff from Washington, as they would put it. And he brought that up. We didn't even ask him about that. And he volunteered that some of folks he works with who are maybe more in that middle space, a little bit on the fence, are going to be, feel a little more likely to be willing to sort of go along in principle with being regulated from the state capital than from Washington, which I think reflects a whole lot of broader things in our society these days. And so, maybe that moves our needle just a little bit with some of those audiences, at least at the margins.
Peter, sorry.
Wondering if you could say something from the standpoint of clean water for all. Are you working with indigenous peoples and tribal communities? You haven't mentioned that.
Oh,
Yeah.
sorry to,
Oh,
to
sorry.
interject, just for purposes of the recording. The question is whether you've been working with Indigenous peoples in this campaign.
Yes. So yes, it is an interesting question. We've been engaging for the states in which there is tribal representation. We've absolutely been doing our best efforts to be able to engage with them. It is tricky because of the way that water rights or like the relationship between tribal nations and states is very different than the relationship between tribal nations and the federal government. So there are very long-term existing, and I'll just say right now that I'm not the lawyer. So I think out of all of these people in the whole room, I'm probably the least able to talk about this, but it just relates differently. So for instance, in Colorado, when we asked to make sure that there were tribal voices represented within their stakeholder outreach process, the state agency very appropriately said that they're a sovereign nation and they need to be here as a peer-to-peer conversation rather than listed as a stakeholder. And so that was the right thing to do, but it does mean that it changes the way that they're brought into these conversations about what we do at the state level. That said, we have a similar coalition to what we have in Illinois. We have a similar coalition in New Mexico that has dedicated efforts to doing tribal outreach and are working with the tribal nations of the state to be able to make sure that whatever happens at the state level is also protective of those tribal waters, and to make sure that we're doing that in a way that is absolutely in alignment with what they are asking for.
So Ryan, did you have a question?
I was going to ask this maybe for David. Got some case studies.
Thank you. So to repeat, I'm gonna shorten this to the intersection of the Illinois initiative with current county, local level programs regarding wetlands.
Yep, thank you. That's a good question and something that I was generally unaware of prior to this. And that's kind of one of the fun parts of my job is that prior to last summer, I never worked on anything wetlands related. It was mostly energy and transportation kind of stuff. And I've had to hurry up to get up to speed on this. So there is, by state law, some counties are allowed to run kind of water reclamation districts. Like we have Metropolitan Water Reclamation District, which is Cook County, but also some of these stormwater management agencies are able to run wetlands programs. From what we've heard, I don't have a lot of specifics, but from what we've heard, they have seen a big uptick in the amount of work that they have to do because there used to be things that were covered by the feds and they are no longer covered. I am not sure yet, and Paul, I'm not sure if you know the answer to this either, if they have had to redraft their, if MWRD and others have had to reconstitute their rules to fill in those gaps, or how
Not
those
yet.
processes have worked.
Are the bill that David has described would takes pains to make sure we don't get in the way of the existing county programs that have been active. but it also has a clause, which I don't remember the exact words of, but the gist of it is that a county any county can create such a program. I know of 2 counties in the St. Louis metro who had years ago authorized on paper, created such a kind of a program, but have never done anything with it. So they might, haven't yet, but that's a possibility where they might decide, especially if the state law passes, they might decide, oh, well, now maybe we better hire some people and do this. So there's at least a couple examples of that. But those are the only ones I know about in the great, vast, rural, I forget how many, 112 counties or
100
something like
something.
that. The other 104 counties not covered by what we just described. It's going to be a brand new idea. And, but this law, we put in the language to make sure that it doesn't get in the way of that. So if counties want to do that, this says that they can't put in a program that is any less stringent than what this covers in terms of the wetlands it covers. But yes, the big picture, we'd like that to happen, actually.
Okay, I think we have time for one brief question. Nate?
Mhm.
All a little bit. There's often this interplay between form and function. It's easy to make something that looks a lot like it's harder to make something that functions like one traditional. I'm curious if you could expound on that a little bit. How you address that.
Sure.
Okay, just one second. So we are going to run out of time, but so the first part of that question, maybe we can start there. And thinking about the Illinois legislation, I think it's a question about how compensatory mitigation programs will work, right? Because this has largely been at the federal level.
Well,
What's
no,
the
it's
state
been at
doing?
the state level too, but not in our state, some other states. But yes, mitigation banks, it is a place, generally speaking, it has to be within the same watershed. It's important to note, it's not by political boundaries, it's by watersheds. So we have a number of them in Illinois. They're not evenly distributed within Illinois for various reasons. One thing that we kind of hope for out of having this state law and program be in place is that we might actually incentivize the creation of mitigation banks in some parts of the state that simply haven't had them. And the other thing I'll say in answer to your question is, you're absolutely right about form versus function. As I said in my slide presentation, just making a place wet, don't make it a wetland, and it certainly will make it a very good wetland. Mitigation banks vary in their quality, absolutely. They are regulated entities. They're supposed to perform to certain standards of quality. They don't always. And that is an issue, but they can be very effective. They can be very good. So that's just a devil in details thing. And that's going to vary from state to state, I'm sure. I know it varies within Illinois and Indiana. There's actually a pretty good mitigation bank I'm aware of in Indiana. It's doing a good job. You might be surprised by that based on what you heard about Indiana and their general attitude toward wetlands politically. But so, it's not necessarily a magic bullet, but it can definitely work and does work in some places and then not so much in others.
All right. I always hate to end discussion. I'm sure our panelists would be happy to take informal questions, but we will formally conclude our program with one more round of applause for our panelists and a big thank you.